Video 13, just entitled The Church. This might be a little bit longer than the 10 minutes, only because I don't want to do this topic in two videos. I just want to get through it in one video. Okay, so we have arrived at the three concerns that were becoming growing concerns in the current feudal system, namely A, the relationship between the tenant and, the lord and the tenant, B, the relationship between the lord and the presumed heir of the tenant, and C, the relationship between the tenant and the presumed heir, which then influenced different areas of law to be created. Yet there was another player in this tenure game besides just lords and tenants. We now turn our attention to the rights of the church. Now, we have come to understand that underpinning this tenure system is the prerogative of the king who, under the concept of dominion, exercises a despotic rule over the captured land of the former Anglo-Saxons. Pre-AD 1066, the king had rights to enforce obligations over men exclusively. The process was controlled through the Witneamote, hopefully I got that right, that pronunciation, made up of the Witan, the elders, and the church, whereas those made up of grievances existing within a tribal community were heard through kinship tribunals called folk right, then determined through the process called the Wergild, aka the man price, which is a settlement paid according to one's status. If not solved here, then an ordeal was used next, which is essentially, if you suffer the torture and survive, God judge you as being right. Now, referring to the king system pre-AD 1066, a quote extracted from Wikipedia on the Witan refers to the attitude of the time. It writes, Liebermann's more subtle position seems to be vindicated by testimony from Abbot Elfric of Eynsham, the leading homilist of the late 10th century, who wrote, "No man can make himself king, but the people has the choice to choose as king whom they please. But after he is consecrated as king, he then has dominion over the people, and they cannot shake his yoke off their necks." Operative phrase here is we want to extract is dominion over the people. Now, after the Norman conquest, it moved into the right of dominion over the land. The type of law post-AD 1066 was managed through tenures, as we have learned, and it's from the tenure system that laws evolved into which they are today. What is not of certainty is the official singular guiding premise that fueled the law to change. The dichotomy not solved by historians is as to whether the tenure laws were created to foundationally restrict the rights of the tenant, in which he eventually found ways around them so more laws were made, or were the laws adjusted to give more rights to the tenant. The latter choice could be easily assumed when we consider that there was a time when labor was hard to find. For instance, after a plague or war, or if a lord wanted to attract a certain bloodline or quality or favor, and so needed to negotiate the terms of the non-freehold agreement in the interest of what the lord wanted or needed, and the tenants want to offer as little in return for the copyhold. Later, as service turned into money payments, this would also change the playing field in the interest of the lord initially, to control the rights of the tenant through payment of money. Now, if the tenant could afford the tenure, he would most likely then negotiate the terms of how that tenure is to pass on to his bloodline, since money became the eventual catalyst for bargaining. Now, moving on to the topic of this video, that being discussing briefly the relationship between king and church, I will go on into this party of interest that has not been really expressed, but is necessary in order to get the full comprehension of what the king was experiencing during his tenure upon the throne. Now, the church was said to hold a third, if not half, of all land interest at the time. This was realized pre-conquest, but more predominantly between the era of 1100 to 1290 AD. These were the Franklin tenures. It became common practice during the period to convey one's interest in land to the church as a means to circumvent the incidents owed at death to the king or lord. So essentially moving portions of military or socage tenure, the latter the most coveted, into tenures of Franklin. The church was a perpetuity fiction, and so how could the king collect his incidents and to a lesser degree worship and marriage rights belonging to the lords if incidents and such are tied to the death of the holder of season? Land that was transferred into the church was seen as a means to avoid payments to the king. One of the practices done was by transferring over to the church, whereby the grantor of the gift or sale of it was said to be able to enjoy the fruits of the land as once before he held directly under the king. He then could hold possession directly under the church, who is without scrutiny of the evolving common law. And so through this type of conveyance to the church, the right to bring the man before the king's court was lost, as he no longer held season but possession as an equitable use under the church. It was discussed, as Bor Laskin mentions in chapter 1, subsection 27, basically that the church argued that because God was a party conveying I surmise then that the church was then able to secure the initial right to hear matters concerning the tenants' rights after death in their ecclesiastical courts. So not a matter to be heard in the king's courts. The king conceding to this, mainly that the God's conveying is, so therefore the church's rights, that made it a matter no longer of the king's courts, thereby evidencing a loss in revenue to the king by means of having the first right to hear the matter otherwise in his own court. The king responded with, by means of summoning a jury to present within the king's court, to allow the church to first prove whether or not God had a requisite interest. Basically, telling the church it had to prove in front of a jury that God needed the land. This gameplay resulted in the church having to concede to proving this point and thus return power back to the king's court as supreme. We can trace this conflict through section 43 of the 1215 Magna Carta, which reads, "No one shall give or sell to any religious house in such a way that he thereby removes it from those holding it in chief of him, or from those who owe him services, nor shall any religious house take the property on such terms." This portion of the Magna Carta was then also transferred into the 1217 Magna Carta, almost word for word. I think it was section 30, I can't remember, section 32, 39, somewhere in that area, to which culminated at the time of Edward I and the 1279 and 1290 Law of Mortmain. Okay, so that's where it originated from, the overreach of the church and then the king's overreach of the church's rights, to now culminate into Law of Mortmain. Now, Law of Mortmain by 1290 made the tenant first receive permission from his immediate lord, who then allowed that same tenant to seek royal permission by license, and that was then also attached to a fine for the transfer into the church. So after 1290, which before in 1279 tenants were granted their first property right to alienate their estate interest to another through quia amoris, lords and tenants again set mind to the issue of wanting to control land while also wanting to restrict the amount of services and payments owed to the king. So we're going to move a little bit away from the church, but again, I want to get this all in one thought, and I think it all ties in nicely together. Now, this was done basically by moving the legal title into more than one feoffee, a person who becomes holder with ownership rights, so that the originating grantor of the legal estate can then, similar to the church scheme, come in under beneficial use and thus not be subject to the common law that evolved since 1200. This became known as a use, the forerunner of the trust, or to the trust, that then became a cash cow for lawyers who had to mitigate issues resulting in locating the original title so as to actually validate by researching the chain of conveyances whether or not that title that that person received was actually going to be enforceable against anyone else who wanted to make a superior claim. So essentially, it was a use upon a use, which is not a consideration of the common law, and so the King's Court, whereby a use was considered repugnant to common law, who deemed the holder as the holding season, and so responsible for the service owed from acceptance of the tenure. The king's compensation was controlling the land after death of his tenants. He received incidents as was previously described in other ELS videos. If no one died, then there was nothing owing to the king. By transferring the estate land as a legal title recognized in common law to more than one feoffee, even if one of them died, there were not only others to hold a legal title, but then the use of the rules of succession to pass his interests on to others was also incorporated. Without death, the king was without right to collect. As we will shortly learn, that this is what led to one of the English most discussed and debated statutes, the Statutes of Uses, 1535, whereby was it created to quash the use, or was it created to control the use by means of establishing a formal registration system that gave this power to Parliament? The next area I want to touch about, that concludes this video, would be, we should delve into the actual statutes but before we maybe do that, we should look into the main and most coveted tenure, which was that of sockage, which then moved into what we now know as the primary tenure of free and common sockage. Please like if you like this, subscribe if you haven't done so, share if you want others to learn where the rights evolved, and donate if you find that you think that this law series is of value to you. Thank you, and by all means, have yourself a great day.